Morning, Your Honor.
Morning.
Morning, Judge.
You may be seated. All right, we are back here today to continue on with the trial of State of Connecticut versus Raul Valle. I would ask counsel to please place their appearance on the record for purposes of today's proceedings.
Good morning, Your Honor. Mark Durso for the State of Connecticut.
Good morning, Your Honor. Tatiana Messina for the State of Connecticut.
Good morning.
Good morning, Your Honor. Kevin Smith for Mr. Valle, who's at my side.
Good morning. Is everyone all set to call the jury and to continue with the charge?
Yes, Your Honor.
Yes, Your Honor.
We'll do that then. Thank you. Welcome back, ladies and gentlemen of the jury. Thank you. Counsel, please stipulate to the return of our juror.
The State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, so before I continue with the jury charge, I just want to thank all of you for your continued attention to the proceedings, as well as your continued attention to arrive here timely each and every day. So I know it's been quite some time. You've been very diligent about getting here and being attentive to the proceedings. So I appreciate that very much. So I wanted to thank you for that. At this time, when we adjourned on Thursday, we were going through the court's instructions as to the law that you are to apply to this case. I am going to pick up where the court left off, and that is at count 4, assault in the second degree intentional, Connecticut General Statute, section 53A, 68-2. The state charges the defendant at count 4 with assault in the second degree, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May, 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause physical injury to one Faison Teel, did cause physical injury to the said Faison Teel with a dangerous instrument, to wit, a knife, in violation of section 53A 68-2 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We'll refer to the court's previous instruction on specific intent at 15. Physical injury is defined as an impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious, it may be minor. Element 2, caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. We refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teel was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or some other person. Element 3, with a dangerous instrument. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of a discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation and even though harmless under normal use may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Faison Teel, and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of the crime of assault in the second degree intentional at count 4, and you shall then next consider the lesser included offense of assault in the second degree reckless. You'll proceed to the court's instruction on lesser included offenses to assault in the second degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statute, Section 53A 68-2 at count 4. This will end your deliberations at count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 4, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 4. Lesser included offenses to assault in the second degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses to assault in the second degree. If and only if you have unanimously found the state has not proved beyond a reasonable doubt all of the elements of the crime of assault in the second degree intentional, and therefore that the defendant is not guilty of assault in the second degree intentional at count 4. The defendant at count 4, the substitute information, is specifically charged with the crime of assault in the second degree intentional. The offense of assault in the second degree intentional under under our penal code is such that it may include the elements of the crime of assault in the second degree reckless. Similar to my previous instructions on lesser included offenses, this brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to assault in the second degree intentional in the order and under the circumstances as provided herein. The fact that I am instructing you on a lesser included offense to assault in the second degree intentional as to count 4 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the second degree intentional or is guilty of the lesser included offense. If and only if you unanimously found that the state did not prove beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, and that the defendant therefore is not guilty of assault in the second degree intentional at count 4, shall you consider the lesser included offense of assault in the second degree reckless directly below it, subsection A. A, assault in the second degree reckless, section 53A 68-3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. Refer to the court's previous instruction, recklessness, at 16. Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction of proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teel was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing serious physical injury to another. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it is used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury to Faison Teel, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes, Section 53A, 60A3 at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 4, even though you have found the elements of the crime proven beyond a reasonable doubt. This will end your deliberations on count 4. 22, self-defense, defense of others. The defendant has offered evidence in this case that he acted in self-defense and or the defense of others. Self-defense and defense of others are two separate but related defenses. Although the court is instructing you on both defenses under this section, the defendant is entitled to and must be given by you a separate and independent determination as to each defense under each count. After you have considered all the evidence in this case, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. In this case, self-defense and the defense of others applies to all crimes charged in the substitute information under each of the 4 counts, along with the lesser included offenses to each of those crimes at each count. In other words, self-defense and the defense of others applies to all offenses submitted to you for deliberations. The statute defining self-defense, defense of others reads in pertinent part as follows. A person is justified in using reasonable physical force upon another person to defend himself, a third person, from what he reasonably believes to be the use or imminent use of physical force. And he may use such degree of force which he reasonably believes to be necessary for such purpose, except that deadly physical force may not be used unless the actor reasonably believes that such other person is using or about to use deadly physical force or inflicting or about to inflict great bodily harm. The determination of whether a defendant reasonably believes physical force to be necessary to defend himself, someone else, from what he reasonably believes to be the use or imminent use of physical force by another individual is 1. Whether the defendant actually believed that the other person was using or about to use physical force or deadly physical force against him, a third person, and 2, whether a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, would have had those same beliefs. Whether the defendant's belief was reasonable is a question of fact for you to determine based on all the evidence presented. The acts of the other individual, James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teel at count 4, leading to the defendant's use of defensive physical force, need not be an actual threat or assault. The test is not what the other person actually intended, but what the other person's acts reasonably caused the defendant to believe was the other person's intention. The state's burden. When evidence of self-defense, the defense of others, is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both the elements of the crimes charged and that the defendant did not act in self-defense or defense of others. If the state fails to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, unless the state proves beyond a reasonable doubt a statutory disqualification, as discussed further below in the section 22 at statutory disqualifications to self-defense, defense of others, and statutory disqualification to the use of deadly physical force, you must find the defendant not guilty, despite the fact that you have found the elements of the charged crime proved beyond a reasonable doubt. The defendant has no burden of proof whatsoever with respect to this defense. Deadly and non-deadly physical force. The law distinguishes non-deadly physical force from deadly physical force. Deadly physical force is justified only when a person reasonably believes that such force is necessary for the defense of oneself or others against the use of imminent use of deadly physical force or infliction or imminent infliction of great bodily harm. Deadly physical force is physical force which can reasonably be expected to cause death or serious physical injury. Physical injury is an impairment of physical condition or pain. Serious physical injury is a physical injury that creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Imminent means that the person is about to use physical force or deadly physical force at that time and not at some unspecified future time. The physical force used by the defendant need not actually have caused a death or a serious physical injury in order to be considered deadly physical force, nor need it have been expected or intended by the defendant to result in such serious consequences. Instead, what determines whether the defendant used deadly physical force is whether the force actually used by the defendant could reasonably have been expected to cause death or serious physical injury. It is up to you to determine, after considering all the evidence, whether the defendant used deadly physical force or non-deadly physical force against James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teel at count 4. If the state claims that the defendant used deadly physical force, the state must prove that beyond a reasonable doubt. In addition, the state may prove that the defendant's use of force was not justified if it can prove beyond a reasonable doubt that while the defendant may have believed that he needed to use such force, his belief was unreasonable in light of all the circumstances known to him at the moment. Whether the defendant's belief in the need to use such force was reasonable is a question of fact for you to determine. However, a person must use no more force than he reasonably believes is necessary for such purpose. Statutory disqualifications to self-defense and defense of others. In addition, the state can defeat the defendant's claim of self-defense or defense of others by proving beyond a reasonable doubt one of the statutory disqualifications to self-defense, defense of others. The statute defining self-defense, defense of others describes certain circumstances in which a person is not justified in using any degree of physical force in self-defense, defense of others against another. These circumstances include provocation and initial aggressor, as more fully instructed below at subsections A and B below. A. Provocation in accordance with Connecticut General Statute Section 53A-19C1. Provocation is one such circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, when he provokes the other person to use physical force against him. In order to provoke the use of physical force by another, it is not enough that the defendant, by his conduct, elicited the use of physical force by another. Rather, the defendant must have embarked upon such conduct with the specific intent to provoke the other into using physical force and intending to cause the other physical injury or death. The defendant must have specifically intended to provoke another into using physical force and then used force to defend himself from the ensuing use of force by the person provoked. It is important to remember that the defendant has no burden whatsoever to prove that he did not provoke James McGrath, Ryan Hines, Thomas Connery Jr., or Faison Teel with respect to their respective count into using physical force against him. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that the defendant provoked the use of physical force by James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teel with respect to their respective count against him. B. Initial aggressor in accordance with Connecticut General Statute Section 53A-19CB. Another circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using the physical force at issue in the case. Under this provision, the state can prove that the defendant was not justified in using physical force in self-defense, defense of others, by proving beyond a reasonable doubt that he was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teel relative to each of their respective counts, and that he neither withdrew from that encounter nor effectively communicated his intent to do so before using physical force against them. To prove that the defendant was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teel relative to each of their respective counts, the state need not prove that the defendant was the first person to use physical force in that encounter. The initial aggressor can be the first person who threatened to use physical force, or even the first person who appeared to threaten the imminent use of physical force under the circumstances. To prove that the defendant did not withdraw and communicate his intent to do so, the state must prove that he did not abandon the conflict in such a way that the fact of his withdrawal was perceived by James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teel relative to each of their respective counts, so that they were aware that there was no longer any danger from the original aggression. It is important to remember that the defendant has no burden whatsoever to prove that he was not the initial aggressor or that he withdrew from the encounter and communicated his intent to do so before he used physical force against James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teel relative to each of their respective counts. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he was the initial aggressor, did not withdraw from the encounter, and did not communicate his intent to withdraw before using physical force. statutory disqualification to the use of deadly physical force. In addition, the state can defeat the defendant's claim of self-defense by proving a statutory disqualification to the use of deadly physical force. The statute defining self-defense, defense of others, describes certain circumstances in which a person is not justified in using deadly physical force in self-defense, defense of others against another. The exception applies only to the use of deadly force. So if you have found that the defendant used deadly physical force, you must consider this the exception of duty to retreat at A below. A, duty to retreat, Section 53A, 19B1. A person is not justified in using deadly physical force upon another person if he knows that he can avoid the necessity of using such force with complete safety by retreating. This disqualification requires a defendant to retreat instead of using deadly physical force whenever two conditions are met. 1, a completely safe retreat is in fact available to him, and 2, he knows that he can avoid the necessity of using deadly physical force by making that completely safe retreat. The law stresses that self-defense, defense of others, cannot be retaliatory. It must be defensive and not punitive. The term complete safety, as used in the statute, means without any injury to the defendant whatsoever. A person acts knowingly with respect to a circumstance described in a statute when he is aware that such circumstance exists. It is important to remember that the defendant has no burden whatsoever to prove that he could not have retreated with complete safety or that he didn't know that a safe retreat was possible before he used physical force. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he did know that he could retreat with complete safety. In summary, if you unanimously find that the state has failed to prove beyond a reasonable doubt any of the elements of a crime to which self-defense, defense of others may apply, you shall find the defendant not guilty and not consider self-defense, defense of others. If you unanimously find all the elements of a crime to which self-defense, defense of others applies have been proven beyond a reasonable doubt, you shall then consider the defense of self-defense, defense of others. If you unanimously find that the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you must reject the defenses and find the defendant guilty. If, on the other hand, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defense alone, you must find the defendant not guilty, despite the fact that you may have found the elements of the crime proved beyond a reasonable doubt. Sympathy. In deciding whether the defendant is guilty or not guilty, you should not concern yourselves with the punishment or potential consequence in the event of a conviction. This is a matter exclusively within the court's function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty, uninfluenced by the possible punishment or consequence that may follow a conviction. You should not allow any display of emotion by counsel during the trial to draw upon your sympathy. There is no place for sympathy in your deliberations. You should not be influenced by any sympathy for the defendant, the defendant's family, the decedent, the decedent's family, the complainants, or for any other person who might in any way be affected by your decision. Implicit bias. As I indicated earlier, your verdict must be based on the evidence introduced in court and my instructions on the law. Our system of justice depends on judges like me and jurors like you making careful, unbiased, and fair decisions. During our interactions with other people, it is not unusual for us to group or categorize people. Sometimes these categorizations involve negative or positive biases or prejudices, which may be conscious or unconscious. Such preferences or biases, whether they are conscious or unconscious, have no place in a courtroom or your deliberations, where our goal is to treat all parties equally and to arrive at a just, fair, and unbiased verdict. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, disability, gender, gender identity, sexual orientation, education, income level, or any other personal characteristic. Techniques that you can use as jurors to check whether any unconscious biases are influencing you include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions, and to consider whether you are making assumptions that have no basis in the evidence. Ask yourself whether you would view the evidence differently if the parties, witnesses, or attorneys had different personal characteristics. In sum, your task is to render a verdict based on facts drawn only from the evidence introduced in the courtroom and from the law as stated in my instructions to you, and not based on prejudice or bias or against any party or person involved in the trial. Duties upon retiring. In conclusion, I press upon you that you are duty-bound as jurors to determine the facts based on the evidence as it has been presented, to apply the law as I have outlined it, and then to render a verdict of guilty or not guilty as to each count. When you reach a verdict, it must be unanimous. That is, all 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in court. It is the duty of each juror to discuss and consider the opinions of the other jurors. Each of you takes into the jury room your individual experience and wisdom. Your task is to pull that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. Despite that, in the last analysis, it is your individual duty to make up your own mind and to decide this case based on the basis of your individual judgment and conscience. Note-taking. If you took notes during the evidence, you may use them during deliberations, and you may discuss your notes with your fellow jurors. Remember that notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes or the notes of any other juror, it is your recollection of the evidence that must prevail. Your notes or the notes of any other juror are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection of the evidence and should not be influenced by the fact that other jurors have taken notes. Notes are only a tool and not always accurate. Do not assume that a voluminous note taker has taken notes that are necessarily more accurate than your memory. You may discuss your notes with your fellow jurors during the deliberation phase. The decision to do so is yours and yours alone. After the trial is concluded, all notes will be collected by court staff and destroyed. In closing, I remind you that you have the right to request portions of the testimony to be read back to you if you deem it essential during your deliberations. You will have all the admitted exhibits with you during deliberations. You may only deliberate when all 12 of you are present in the jury room. Inform the judicial marshal or court officer when you have reached a verdict, but do not tell him or her the verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out as a note signed by the foreperson marked with the time, and please be as specific as possible. You will have the exhibits with you during your deliberations. We will also send in with you a computer on which you will be able to view or hear digital evidence with instructions on how to use the computer, which will be marked as a court exhibit. You will also have with you in the jury room a copy of these instructions entitled Jury Charge, which will be marked as a court exhibit. I remind you, however, that you should follow all the court's instructions and not single out some and ignore others. They are all equally important. Do not begin deliberations until you have selected one of your members to be the foreperson of the jury and you have received the jury charge, the substitute information, the device, instructions on how to access the device, and all fully admitted exhibits. So at this point in time, I am going to ask the jurors to please step out and go into the jury room for a brief moment. I do have to make some comments on the record. Do not begin your deliberations just yet, as the alternate jurors will be in that room with regular jurors. So please remain silent just for a few moments as a jury panel, and I will be bringing you right back into the courtroom. Thank you. Comments, any questions, counsel, any questions, comments, or exceptions to the court's charge?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, and it's a good thing we told him just a brief moment. We'll bring the jury back in, please. Thank you.
Point out one more, Your Honor.
Thank you. All right. Ladies and gentlemen of the jury, at this time I am going to ask all regular jurors to please stand. If you're a regular juror, please stand. Alternate jurors, please remain seated. Regular jurors, I'm going to direct you to the deliberations room. You're going to go into the room. You will be deliberating shortly. I will ask you to hold off until such time as you have all of the exhibits. You've selected a foreperson, you have the substitute information, and you have my jury charge as well as the device and the instructions, okay? So I would ask all regular jurors to please go into the jury room. Once you have all of those documents and the device, and you've selected a foreperson, you can begin your deliberations on this case. The alternate jurors, please just be patient with the court for just a moment. Thank you. Madam Clerk is going to state your name and ask you to stand just to be confirmed. Throughout the trial, I know it may be somewhat frustrating to hear the evidence and not participate in the actual deliberations, but you do perform a very important function by being here, and we appreciate that. Now, while it is unusual, alternate jurors are sometimes called upon to take the place of a juror during deliberations. For that reason, I am going to ask you to go back to the jury assembly room and report back to that room and remain there every day until such time as there is a verdict. The same instructions are going to apply to you as I've repeated them throughout the trial. Do not read, listen to, or watch anything about this case. Do not speak to anyone or let anyone speak to you, not even the other alternates or one of the primary jurors. Do not make any private investigations or do any research. When there is a verdict, we will bring you into the courtroom so that you can hear what the verdict is. So I apologize for this, but it has happened. So I am going to ask you to please abide by your oath. I do continue to appreciate the service that you are giving us. It is an extremely important one. The marshal is going to escort you to the jury deliberations room, and I will ask you to continue to report here daily back to the jury deliberations room. The clerk will update you throughout the day, and once there is a verdict, you'll be brought back in to hear the verdict. Thank you so much. Thank you. Okay, counsel, this time I am going to ask you please to meet with Madam Clerk and make sure that all full exhibits are going to the jury and that only full exhibits are going to the jury. Please make sure that the latest substitute information is going to the jury. Also, please check the instructions for the device. Please make sure that you are okay with those instructions. I did ask you to look at the exhibit list to make sure that you were okay with the description of each exhibit. If you are, then we'll mark that and we'll have that go in as well. And then I will just state for the record that there were two things in my charge that I caught while reading the charge. I intend to make that change. I believe they were both under self-defense. Yes, they were. Under initial aggressor, B was before using physical force against, and it was them. I had to add them. And then there was also at the end in describing statutory disqualifications just added, and I did do it on the record, beyond a reasonable doubt. All right, so I will make those two changes, and I will submit that to the clerk as an exhibit, our final exhibit to go into the celebration. Was there something else?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, so then we're going to take a brief recess, and I'll come back on the bench just to confirm that you've gone through the exhibits, and I'll hear any issues, and then I'll have Madam Clerk deliver all of the exhibits and the device for deliberations. Court's going to take a 10-minute recess. Thank you.
All right, for some recess.
All right, counsel. I just want to go over the exhibits and everything that's going in to the jury. So I have asked Madam Clerk to make the exhibit list, the substitute information, the computer instructions, and the jury charge that I just handed the clerk, a court full exhibit. So those items will be going to the jury to have with them during their deliberations. Do either of you have any questions on that, or would you like to review those exhibits before they go in?
The state does not have any issue with that, Your Honor.
Defense has no issues, Your Honor.
Okay. So then, aside from those exhibits and obviously the device, have you reviewed all of the full exhibits going in to the jury for deliberations? My question is, are all full exhibits going in? Are any full exhibits not there that you are aware of?
No, we've reviewed all of the exhibits, Your Honor, and we believe we've accounted for every exhibit that was submitted as a full exhibit.
Defense agrees, Your Honor.
Okay. And I just want to make sure, are there any exhibits for ID only that are going in that you noticed?
No, Your Honor.
No, Your Honor.
Okay. All right. Is there anything else that you would like to bring to the court's attention relative to the deliberations?
No, Your
Nothing
Honor.
from the state, Your Honor.
Okay. So at this point in time, Madam Clerk, just for the record, if you could please let me know in terms of full exhibits, core exhibits, what are the references and what are the identification numbers?
So court exhibit number 3, is the jury charge.
Okay, so jury charge for Exhibit 3 full. Okay,
And then number 4 is the juror laptop instructions, which is full as well.
laptop instructions is 4 full, thank you.
And then the substitute information is full, number 5.
Number 5 full, substitute info.
And the exhibit list is number 6 full.
Right, with that then, I would ask Madam Clerk to please deliver to the jury the full exhibits, as well as the full exhibits that counsel have had the opportunity to go through. And the jury can start deliberating. It is about 2 minutes to 11. If I receive any notes, I will of course inform counsel. If you are planning to leave or remove yourselves from this immediate area, just please let the clerk know how to best reach you. And we'll be able to do that if you receive a note, okay? Thank you so much. Court stands in recess.
All right.